was a whip lab.
For the first time.
Acted dumb. His sister was even smarter, and she was the instigator. And she'd get him to do shit.
Knock it down.
I know, they are.
My best
And I
time
put
ever.
I had a little
Drone
garden,
doesn't show up.
and I put electric fence up.
So what are you gonna do next year? You're
Wire,
gonna do the age
just this
gap?
high off the ground, a single wire. No, Abby went up to it, and she hit it, and she
It's 2 o'clock, and I'm going to call to order the September 11th, 2014 City of Tarpon Springs Code Enforcement Meeting. Mr. Trask, could you lead us in an invocation?
If everyone could rise, please, if you can. Our Father in heaven, we seek blessings on the tasks before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We gather to make decisions for our community. May we use only our best skills and judgment, keeping ourselves impartial and neutral as we consider the merits and pitfalls of each matter that is placed before us, and always act in accordance with what is best for the city of Tarpon Springs and our fellow citizens. This we pray. Amen.
Now we'll say the Pledge of Allegiance.
It's back there. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I don't care. Get it if you want.
May we have a roll call, please?
You have the hearing procedures there somewhere.
Mr. Sansoda is absent and excused. Mr. Vesey,
Here.
Ms. B. Casey,
Here.
Mr. Kramer,
Here.
Ms. Archer. Here. Mr. DeMazis,
Here.
Mr. Zableski, absent and excused. Mr. Plunkett. Ms. Dabbs. Here. That completes the roll call.
Thank you. Now I'm going to read the hearing procedures. The Code Enforcement Board hearing procedure. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such appeal shall be filed within 30 days of execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure of this board follows with each case on its agenda is as follows. First, the city presents its witnesses and exhibits, after which the violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the violator is allowed to make a presentation and present any evidence or documents. Then the city can question the violator's witnesses. After both rounds of testimony, both on the part of the city and on the part of the violator, each party is asked to give a closing statement. First by the city, then by the violator. After those three steps are taken, this board then closes the public hearing portion of the case to discuss it and take appropriate action. Before we begin the public hearings, we will have all potential witnesses stand up and be sworn in by the secretary of the board. At this moment, please take a moment to turn all your cell phones off also.
Anyone that's going to
potential
speak,
witnesses.
stand up, raise your right hand, face the clerk, and take the oath.
Do you swear the testimony you're about to give is whole truth and nothing but the truth?
I do.
Thank you. You can be seated.
At this moment, I'm going to have Mr. Trask say a few words.
I know there are a lot of you in the audience that are here for this case on the agenda item number 5, 94 South Highland Avenue. Just want to let you know that unless you're specifically called by the city as a witness or the alleged violator as a witness, you will not have the opportunity to speak today. This board sits as a quasi-judicial board. They're supposed to make their determination basically solely upon the evidence and testimony that's presented. And so I don't want you to sit here all through today's hearing with the understanding or thought that you're going to go ahead and speak because this is a public hearing. You are not going to have that opportunity today because it is quasi-judicial. You absolutely have the right here to sit and listen, though, if you want to go ahead and do that. I just didn't want you to waste your time if you didn't want to wait. So with that, Mr. Chairman, I think we can go ahead and get right back to the agenda. So I'll give it back to you.
Thank you. In addition, in regards to case number 5 on the agenda, because it does require a city staff witness who is currently in a meeting, we are going to be moving that item to the end of the agenda today. Okay. Number 1 is deferred. Agenda item number 2 is case number 14-800000381.
Good afternoon. My name is Cindy Sanner. I'm the Code Enforcement Inspector for the City of Tarpon Springs. I do not believe that Mr. Nicholas is in the audience. This is case 14-800000381. The property address is 1117 East Lime Street. It is a vacant lot, and the property owner of record is Mark Nicholas. On June 2nd of 2014, we received a complaint that this vacant lot was overgrown and the people were dumping trash on it. A site visit on June 3rd confirmed the complaint. This property was in violation of codes 8-22, accumulation of trash and debris on private property, 8-40, duty of maintenance of private property, and 8-52, nuisance prohibitions. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was issued a courtesy letter on June 4th, a notice of violation on June 17th, and a notice of hearing sent first-class mail and certified return receipt on July 3rd. A site inspection was conducted prior to each notification being issued. I posted the property on July 30th. We received a call from the property owner on August 12th. He stated that he would have the front half of the property mowed, but he doesn't have the money to do the whole property. I deferred the case to this code board hearing, and we issued a deferred notice of hearing on August 12th and mailed that first class and certified return receipt. The property was posted on August 28th, and yesterday I conducted a site visit and found that there was no change and the photo was taken. This property is in violation of codes 8-22, 8-40, and 8-52. I recommend a compliance date of September 25th and a daily fine amount thereafter of $50 per day. I did speak to the gentleman who has been contracted to mow the property. He will be mowing the front half this weekend, but he's unsure when the property owner will allow him to do the back half of the property.
Bobby, will you put that photograph into evidence, please?
Yes, sir.
Thank you.
Does it all have to be mowed before it's,
It all has to be mowed before it'll be in compliance.
so doing half is kind of a moot point, right?
Well, it hasn't even been done yet, so right now he's in violation, in full violation of the codes.
Okay.
Even if he does half, it needs the entire property, and he knows that.
Are there neighbors close by?
I'm sorry?
Are there neighboring houses really close by?
Yes, on both sides and in the rear.
Okay.
Any other questions for the city? Would someone like to make a motion?
I'll make a motion. Oh, I'm sorry, Vic. Go right ahead.
I move based on the testimony, evidence, facts presented in law, that at the time of the alleged violation, sections 8-22, 8-40, and 8-52 of the Code Ordinance of the City of Tarpon Springs were in force. The respondent has until September 25th, 2014, to come into compliance with a code section, or a fine of $50 per day shall be imposed for each day thereafter that the respondent remains in the violation of said code sections.
Second.
Any discussion? Do we have a roll call, please?
Ms. Dabbs? Yes. Mr. DeMossis?
Yes.
Ms. Archer?
Yes.
Mr. Kramer?
Yes.
Ms. Casey?
Yes.
Mr. Vesey?
Yes.
Motion carries.
Agenda item number 3, case,
I'm sorry. This is case 14-800-00430. The property address is 701 Bayou Avenue, and the property owners are George and Mary Patakis. They are not in the audience. Complaint was received on June 20th that the carport roof was damaged. I confirmed the complaint on the same day, and the carport roof was damaged and beginning to fall down. This is a rental property. This property was in violation of codes IPMC 9-1, International Property Maintenance Code adopted, IPMC 304.7, roofs and drainage. The property owners of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, were issued a notice of violation on June 23rd and a notice of hearing sent first-class mail and certified return receipt on July 23rd of 2014. A site inspection was conducted prior to each notification being issued. Excuse me. The property was posted on July 31st, 2014. On August 7th, we received a call from the property owner. He had been in the hospital and had not been able to find someone to do the work. So I deferred the case to today's hearing. We issued a deferred notice of hearing, sent first-class mail, and certified return receipt on August 7th. We received a call from the property owner on August 27th. He was still unable to get quotes. No one was calling him back with bids. This property was posted on August 28th. A reinspection was conducted yesterday, September 10th. I found no change and photos were taken. This property is in violation of codes IPMC 9-1 and IPMC 304.7. I recommend a compliance date of October 9th of 2014 or a daily fine thereafter of $50 per day.
Anyone have any questions for the city?
Is there somebody living there?
It's a rental. There are tenants there.
I don't think. Have you heard back from the guy since he called and said he was in the hospital?
Yeah, he called the 27th of August.
Okay.
Bad.
I don't like
Bobby, would you take those photographs as evidence, please?
Yes, sir.
Thank you. Would anyone like to make a motion?
that. I would. I move based on the testimony, evidence, facts presented in law that at the time of the alleged violations, IPMC 9-1 and IPMC 304.7 of the Code of Ordinances of the City of Tarpon Springs were in force. The respondent has until the 9th day of October 2014 to come into compliance with the code sections, or a fine of $100 per day shall be imposed for each day thereafter the respondent remains in violation of said codes.
Second.
Any discussion? Roll call?
Ms. Dabbs? Yes. Mr. Demasis?
Yes.
Ms. Archer?
Yes.
Mr. Kramer?
Yes.
Ms. Vaquesi?
Yes.
Mr. Bessie?
Yes.
Thank you.
Agenda item number 6.
This is case 14-800000469. The property address is 1147 Tooks Road. The property owner is J.P. Morgan Chase Bank National Association. This is a proactive case. On July 2nd, I noticed that the property was overgrown, in disrepair, and vacant. This property was in violation of codes 8-40, duty of maintenance of private property, 8-52, nuisance prohibitions, IPMC 9-1, International Property Maintenance Code adopted, IPMC 301.3, vacant structures and land, IPMC 304.10, stairways, decks, porches, and balconies, IPMC 304.2, protective treatment, and IPMC 304.6, exterior walls. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was issued a notice of violation on July 2nd of 2014, and a notice of hearing sent first-class mail and certified return receipt on August 5th. A site inspection was conducted prior to each notification being issued. The property was posted on August 28th. I conducted a reinspection yesterday, September 10th, and found no change, and photos were taken. This property is in violation of codes 8-40, 8-52, IPMC 9-1, IPMC 301.3, IPMC 304.10, IPMC 304.2, and IPMC 304.6. I recommend a compliance date of September 30th of 2014, or a minimum daily fine amount of $50 per day.
Is there anyone present to speak on behalf of J.P. Morgan Chase Bank?
Protected behind Anderson Park.
Whilst we're looking at those photos, does anyone have any questions from
I have a
Ms. Sainer?
question for Ms. Sainer.
Yes.
Have you had any contact with J.P. Morgan Chase Bank?
No.
They've made no response to any,
No, I believe they did sign the certified letters. Hold on.
Cindy, is that on the lake? It's not on water.
can I get an answer first? Just
Oh,
a
I'm
second.
sorry.
They did sign the certified. It usually takes them a while to figure out if it's theirs, and if so, to contact the property preservation company. I did notice that there was an MCS property preservation sticker on it when I was out there yesterday, so I'll be contacting them.
Unfinished, Ms. Casey.
That's this one, not that one.
Go ahead.
I just wonder, is that on the lake or is it
No.
across the street?
No, it's at the corner of, when you first drive in from US 19, it's the first house on the left by the stop
Oh,
sign.
Okay. Never mind.
Any other questions? Would someone like to make a motion?
I'll make a motion. I move based on the testimony, evidence, facts presented in law that at the time of the alleged violations, sections 8-40, 8-52, IPMC 9-1, IPMC 301.3, IPMC 304.10, IPMC 304.2, IPMC 304.6 of the Code of Ordinances of the City of Tarpon Springs were in force. The respondent has until September 30th, 2014 to come into compliance with the sections, or a fine of $50 per day shall be imposed for each day thereafter the respondent remains in violation of the said code sections.
Second.
Any discussion?
Mr. Chairman, may I? These are the photographs that were passed down. And those are on that case. Okay, not on this case. These are the codes that were just read. These are the only codes that are on this case we're talking about right now.
You know what, this case got deferred.
This is what we're talking about.
Actually, this is the one we're talking about.
Okay. We skipped one.
I think they're waiting until use that last.
we had to move it to the back.
'Cause,
We also jumped over 4. You didn't mention that 4 was deferred. That may be the one that he's mentioning. So,
they're
Okay.
actually at the end. Thank you so much.
I believe we're ready for roll call.
Ms. Dabbs? Yes. Mr. DeMasis?
Yes.
Ms. Archer?
Yes.
Mr. Kramer?
Yes.
Ms. Vaquesi?
Yes.
Mr. Bessie?
Yes.
Thank you. Carries.
And just to clarify, I did step over case number 4, which was deferred, and then just to verify that agenda item number 5 has been moved to the end for the city witness. Okay, so that takes us to agenda item number 7.
This is case 14-800000511. The property address is 905 Gainesville Drive, and the property owner of record is Ann Hale. And I do not believe anyone is in the audience for this case. Annie? On July 15th, we received a complaint that this property was overgrown. I conducted a site visit on July 18th and confirmed the complaint. This property was in violation of codes 8-40, duty of maintenance of private property, and 8-52, nuisance prohibitions. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was issued a courtesy letter on July 19th, a notice of violation on August 7th, and a notice of hearing sent first-class mail and certified return receipt on August 19th. A site inspection was conducted prior to each notification being issued. The documents were sent to 2 addresses, and all of the documents were returned. We were unable to find an alternate address for the property owner. I posted the property on August 28th, conducted a reinspection on September 10th, and found no change, and the photos were taken. This property is in violation of codes 8-40 and 8-52. I recommend a compliance date of September 25th of 2014 or a daily fine amount thereafter of $25 per day.
Any questions for the city?
So you have you can't get in touch with anybody responsible for this property?
No, all the letters came back.
Wow.
Please place the photos into evidence.
Yes, sir.
Would anyone like to make a motion?
I will.
Thank you, Madam Chair.
I move based on the testimony, evidence, facts presented in law that at the time of the alleged violations, Section 8-40 and 8-52 of the Code of Ordinance of the City of Tarpon Springs were enforced. The respondent has until the 25th of September 2014 to come into compliance with the code sections, or a fine of $25 per day shall be imposed for each day thereafter that the respondents remain in violation of the said code sections.
Second.
Any discussion? Roll call, please.
Ms. Dabbs?
Yes.
Mr. Demosis?
Yes.
Ms. Archer?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
Yes.
Mr. Bessie?
Yes.
Motion carries.
I have agenda item number 8.
This is case 14-800000512. The property address is 907 Gainesway Drive. Excuse me. Property owners of record are Donna C. LaFury and Gulf Shore Trust LLC. We received and I don't believe anybody is in the audience for this case. We received a complaint on July 15th that this property was overgrown. I confirmed the complaint on July 18th. The property was in violation of codes 8-40, duty of maintenance of private property, and 8-52, nuisance prohibitions. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was issued a courtesy letter on July 19th, a notice of violation on August 7th, and a notice of hearing sent first-class mail and certified return receipt on August 21st. A site inspection was conducted prior to each notification being issued. The documents were sent to 3 different addresses. On August 25th, we received a letter from the property owner stating that she walked away from the property, which is now in foreclosure. She also stated that the property was being sold the first week of September. A copy of all of the notices were sent to the potential new owner on August 27th. On September 4th, we received a call from Lisa Defoe, who stated that she was buying the property and will make sure that the violations are corrected. She anticipates a closing date of September 15th. I posted the property on August 28th. We received another call from Lisa on September 10th, and she stated that her closing was scheduled for September 15th. that she already had a landscaper give her an estimate on taking care of the property, and she asked for more time just in case. I conducted a reinspection yesterday, found no change, photos were taken. This property is in violation of codes 8-40 and 8-52. I recommend a compliance date of September 30th, 2014, and a daily fine amount thereafter of $25 per day. I'm confident that this property will get taken care of before the compliance date.
Does anyone have any questions of Ms. Sanner? Would someone like to make a motion, please?
I'll make a motion. I move based on the testimony, evidence, facts presented in law that at the time of the alleged violations, Sections 8-40 and 8-52 of the Code of Ordinances of the City of Tarpon Springs were enforced. The respondent has until, I'm going to give her till October 15th, 2014, to come into compliance with the code sections, or a fine of $25 per day shall be imposed for each day thereafter the respondent remains in violation of the said code sections.
Second.
Any discussion? I think the extended date is appropriate in this situation. May we have a roll call, please?
Ms. Dabbs? Yes. Mr. DeMasis?
Yes.
Ms. Archer?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
No.
Mr. Bessie?
Yes.
5-1, carries.
Agenda item number 9.
Is there anyone in the audience for this case? Property owner? Are you the property owner, sir? Your name is? Okay. If you would please go to the desk.
Eugene, were you sworn in at the beginning of the meeting? Super.
Yes.
Mr. Thomas?
Yes, sir.
Would you just state your name and address into the microphone, please?
Eugene Bryant Thomas III, 1441 River Oaks Drive, Tarpon Springs, Florida, 34689.
Thank you. Of course, Ms. Sanders is going to speak first, and then you'll have an opportunity, okay?
This is case 14-800000561. The property address is 1441 River Oaks Drive, and the property owners of record are Eugene Thomas III and Maurice Wilder. On August 4th of 2014, we received a complaint that there was a boat parked on the front lawn. I conducted a site visit on August 5th, and I found a large boat parked on the driveway, blocking the sidewalk. There were trash cans on the driveway in public view. A truck with an expired tag filled with tree debris was parked on the street. I called dispatch and requested that an officer be sent to issue a ticket to the truck owner. There have been 5 cases since 2011 regarding this property. This property was in violation of codes 8-16, pre-collection practices, 8-40, duty of maintenance of private property, and 42.00, parking or storage of recreational vehicles in residential areas. The property owners of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, were issued a notice of violation on August 5th and a notice of hearing sent first-class mail and certified return receipt on August 21st. A site inspection was conducted prior to each notification being issued. The property was posted on August 28th. Yesterday, I conducted an inspection and found that the boat was gone and the trash cans had been removed from public view. The property is in compliance. However, please find the property in violation of codes 8-16, 8-40, and 42.00 to be established.
Mr. Thomas, do you have any questions of Cindy Sanner with the city?
No, I just think I'm in compliance, and I don't know what a recreational vehicle was, because it was actually a truck that was parked in my yard, which, I mean, if you want to talk about a recreational vehicle, I cannot park my bicycle in my yard, because that's a recreational vehicle. that boat is a commercial vehicle. It's not recreational, it's registered commercial. So I don't know how that would be recreational.
Attorney Trask, can you please address that?
And as far as my truck, I have reckless driving. I had another truck hook up to the boat in the street, which is legal, I've been told. And then a cop came, knocked on my door, told me to put the boat into the driveway. And I said, I can't do that. I'm not allowed to drive. I have a reckless driving, you know. He said, well, as soon as I pull away, I want you to move it, you know. Well, I don't have the keys to the truck. It's my friend's truck. Okay, well, call your friend up, get him over here, put your boat in the driveway, and then, you know, put your truck in the street. Well, then they write me a ticket for my boat and my truck when the cop told me, and I applied to what the cop told me to do. I mean,
Well, we can't answer anything about those ticket issues, but I'm going to consider that kind of your statement here about what happened. Cindy, Ms. Sander, do you have any questions or comments for Mr. Thomas?
No, I do not.
Okay, and I think we're going to clarify the parking element here. And are we attempting to clarify that commercial versus personal and driveway versus road?
A boat is considered a recreational vehicle per code 42.00.
Okay.
even though it's registered commercial?
There's no discrimination between the two.
And the
for
idea
boat. A
here
boat
is that it's not City of Tarpon Springs code does not allow a boat to be parked in your driveway.
Well, no, it allows the boat to be parked in the driveway,
the
but
sidewalk.
it cannot block the sidewalk. It cannot encroach onto the sidewalk.
I'd like to ask a
Get
question
a
of
smaller boat.
the inspector, if I could.
Go right ahead.
Ms. Sainer, in reading your recommendation, you indicate that the property is in compliance, but you want this to be established. Can you explain for the board what the purpose of having it established?
The next time we either receive a complaint or I drive by the property and I find any violations of those three specific codes, the daily fines would start at that point, and then the case would be brought back to you for you to establish what the daily fine amount would be.
And I'm going to assume, but maybe you can answer this, is the reason, another reason that you want it to be established because there has been past problems with this particular piece of property?
That is correct.
Okay. So had there not been past problems, you probably would not be going for this
That's
to be
correct.
established? Okay.
Mr. Thomas, did you follow that exchange right there
Yes.
about that
Yes, very well.
more or less conversation
But-
today? We're not here to fine, but we're setting a precedent that,
Yes.
okay.
Okay.
Go ahead. Mr. Trask?
Yeah, I'm going to go ahead and read the definition under the Land Development Code of recreational vehicle. Recreational vehicles shall include, but not be limited to, any motorized home, travel trailer, small cargo trailer, boat, boat trailer, houseboat, horse, van, slide-in or pop-up camper, collapsible trailer, and similar vehicles. So under the city's code, it would be a recreational vehicle. And I'll just read that provision of the code dealing with that. 42.00. Reads, no recreational vehicle shall overhang, encroach upon, or be parked on any sidewalk, street, or public right-of-way. All recreational vehicles parked in the front yard shall be located on a driveway or circular drive. Recreational vehicles may be parked in an interior side yard, provided that no part of the vehicle is located closer than 2 feet of the side lot line. Recreational vehicles may be parked in a rear yard. Recreational vehicles may be parked in a side yard adjoining a side street or in a rear yard of a through lot, provided that the vehicle is concealed by an opaque screening consisting of a fence or hedge not less than 6 feet in height. In all cases where a recreational vehicle is parked, the grass located under such vehicle shall be trimmed at the same height as the rest of the yard. All recreational vehicles shall be stored in a safe condition. Under no circumstances shall drums, barrels, concrete blocks, lumber, or similar devices be utilized for the storage of recreational vehicles. All recreational vehicles and trailers parked in a residential area under this section shall not be classified as abandoned under Section 40 of the code. No recreational vehicle shall be used for living, sleeping, or housekeeping purposes except with an approved recreational vehicle park. Repair of recreational vehicles parked in a residential area under this section shall be limited to minor maintenance, and in no case shall repair be conducted as a business for profit or in any manner which renders the vehicle inoperative. Recreational vehicle storage areas incorporated into a residential project design shall be concealed by opaque screening consisting of a fence or hedge no less than 6 feet in height. The last statement is recreational vehicles shall include but not be limited to any motorized home, travel trailer, small cargo trailer, boat, boat trailer, houseboat, horse van, slide-in or pop-up camper, collapsible trailer, and similar vehicles. So that was a reading of the entire section 42.00.
Okay, closing statements from the city?
I have no closing statement.
Thank you. Anything to close with?
I'm just a little confused. What he just read, like my neighbor has a boat in their driveway, so he's not allowed to have that boat in his driveway?
We're talking about your case, sir.
Okay,
This is factually based upon your case.
okay.
There may be hundreds of other people in the city who have violations, and they also may be cited, and they also may be set for code enforcement hearing. So the board can only consider yours.
Okay.
Okay, then, I'm going to close the public testimony of this case. Any discussion?
Motion first.
Motion, of course. Would someone like to make a motion, please?
I'll make a motion. I move based on the testimony, evidence, facts presented in law that at the time of the alleged violation, August 5, 2014, Sections 8-16, 8-40, and 42.00 of the Code of Ordinances of the City of Tarpon Springs were enforced. The respondent is now in compliance, but a record of the alleged record of the violations of 816, 840, and 42.00 are to be established.
Second.
Any discussion? A roll call, please.
Ms. Dabbs? Yes. Mr. Demasis?
Yes.
Ms. Archer?
Yes.
Mr. Kramer?
Yes.
Ms. Vaquesi?
Yes.
Mr. Bessie?
Yes.
Motion carries.
May I just for a second? There is a specific sheet for that particular thing. You did fine, but there's one so you don't have to wing it.
Okay, we're all done, Mr. Thomas. Thank you for coming.
Okay.
Appreciate it.
Can I just ask one thing? Am I allowed to, like, because I'm a charter captain, am I allowed to bring my boat home and wash it?
I'm not able to answer
Your
that question.
boat's too big for a residential property. You cannot park that boat to code anywhere on your
I don't mean
property.
park it, I just mean bring it home and wash it and then take it back to storage where it is now. Am I allowed to do that?
The boat's too large for your property, sir.
The answer is no.
No? Okay.
Thank you for coming.
Okay, you guys.
And I just need to mention something about this one. The city is pulling this, so we don't have to consider an affidavit of non-compliance. They say voided here.
That was a nice
They're pulling it from the agenda.
Yeah.
Okay, but we still have all the other affidavits.
Yeah, and we need to make sure there's nobody.
Ms. Casey, I think if you look at the,
Problem is see the roof.
Oh, I didn't see it.
Is anyone in the audience for
yeah.
any of the affidavits of noncompliance? Still need to get the other agenda item on.
Yeah, we'll do that last. The other employee is not here yet.
Okay.
I think you're on.
So we just need to mention the property addresses.
The property addresses for the affidavits of noncompliance, we're going to have one that's going to be pulled. So the property addresses are for noncompliance: 1474 Lakeview Drive, 1600 Lonesome Pine Lane, 222 Earl Street. Oh, excellent. Now what do I do?
And we just have them come up when that case comes. Let's go do the other ones first.
Okay. Who's going to help me with the affidavits of noncompliance?
I'll do them. What do you want me to do?
So we're gonna do number 11, 12, 14, and 15.
I just want to mention those other addresses that haven't been mentioned. Is anyone here on the case of 1449 Lake Tarpon Avenue or 318 through 322 East Boyer Street? Okay. So we'll just go ahead and poll and move down item number 13, because there's someone here on that one.
Jesus.
Did that make sense?
We're so confused.
I know I'm thoroughly confused, but I'll take a shot at it. I move we accept the affidavits of noncompliance in case 13200000062, case 13-2000064, case 14-800000422, case 14-800000441.
May I have a second?
Second.
All in favor?
Aye.
Aye. Opposed? Accept affidavits of noncompliance.
I move we accept the affidavits of compliance in case 14-200000001, case 14-800000413, case 14-800000422.
Second.
All those in favor?
Aye.
Aye. Opposed? Motion carries.
Okay, so let's bring back item number 13.
So item number 13, case number 14-800000270, 222 Earl Street. Would you please state your name and your address in the microphone, please?
My name's Peter Kaczynski. My address is 604 Baynard Drive, Tarpon Springs, Florida, 34689. And I'm here regarding 222 Earl Street, Tarpon Springs, Florida, 34689.
Thank you.
Okay, let me just go ahead and handle this item. The city has issued an affidavit of noncompliance on this property. Are you in agreement that it's still not in compliance?
No, I'm not in agreement.
Okay. Are you saying that you are in compliance?
Well,
Just answer question yes or no, because we need to do something different. Do you believe you're in compliance as of this date? Because if you do believe that you're in compliance, the city needs to go first and present their case.
I do believe it. I'm in compliance.
Okay. So, Mr. Chairman, at this point, we need to go ahead, Ms. Sanner, and for you to put on your case to prove up that the property is still in noncompliance. Do we have that file here? Okay.
Yes, we do.
Okay. So we're going to just put it on as a affidavit compliance, non-compliance hearing. So,
The property was brought to you on August 14th, and at that point in time, the property was not in compliance. You gave a compliance date of August 28th, and on the 29th of August, I conducted a site visit, and the pool had not been covered, nor was the equipment on, and the pool water was still green. The property was in non-compliance, and you accepted the affidavit, and today you're accepting the affidavit of non-compliance. You've not gotten any notification from anybody saying that the property was in compliance to go back and do another inspection. But as of the 29th of August, the property was in non-compliance.
yes.
Okay. Mr. Kaczynski, thanks for coming. You can ask Ms. Sanner, the code enforcement officer, any questions at this moment if you'd like.
Okay. Earlier, I was listening to other people's cases, and you were going line by line with the codes. There was 3 codes that we were non-compliant on, and 2 of the 3 codes are compliant now. Is that what would you agree with that?
2 of the 3 are in compliance?
Yeah, well, basically, long story short.
Yes, but all 3 have to be in compliance in order for the case to be totally in compliance. Like, we don't do piecemeal. Everything has to be in compliance.
Okay. I have an actual problem having the pool be non-green. I don't live there. I haven't lived there
I know.
since 2011. The banks changed the locks on the property and locked the gates, and I have no way to get in the backyard to clean.
I've been in
the pool.
contact with Safeguard Properties, and they had gone out to bid, but they have just not been able to get the pool covered. So it's in Safeguard's hands right now.
Okay, Safeguard is hired by city, is that how that works? Or
It's
Safeguard-
hired by the bank, right?
Okay, and so I don't understand how I would be a non.
Because you're still the property owner of record. Your name still appears on the tax collector rolls and on the Pinellas County property appraiser rolls. Once the foreclosure has been, has gone through and the bank's name appears, the fine still attaches to the property, but I believe, sir, Mr. Trask, it still attaches to any property that this current property owner has.
That's correct.
If I may interrupt, maybe, Mr. Kaczynski, might be a moment, since you did ask her some questions, why don't you take a moment and share with us why you believe that you're in compliance now?
Okay.
And perhaps a touch of background.
Okay, yeah, sure. Well, the property was vacated by my family in 2011, and at that point, you know, we were trying to sell the property, and it didn't sell. So we did get a notice of foreclosure, but we're working with the bank right now on a deed in lieu. I just received paperwork last week saying the deed in lieu is a high probability, and they're moving forward with it. So we're hoping to not have any attachment to the property soon, whether it be foreclosure, which is running concurrent with the deed in lieu process. But basically, they have a lawn service that they hired since they did take over the property back in 2011, and the lawn service evidently, from what I was told by the neighbors, was that the guy had a hard time getting into the backyard through unlocking the gate, the locked gate that surrounds the backyard and the pool. And so he just took a whole entire fence panel off and just threw it down to the side. And that's the reason why we were cited for a violation. Once that fence panel was taken down, somebody obviously drove by and said, "Whoa, major problem here," and I was cited for a code violation. As soon as I received the mail, it said that there was an issue over at the property, which also there was some yard debris, some sticks and stuff in the yard. I went ahead and took care of the sticks, and I nailed up the board with long nails, making sure hopefully that nobody would take it back down. The other issue of having a green pool, I saw there's nothing I can do about that. I don't live there. I don't have access to the property. I'm locked out of the backyard. I'm locked out of the house. I have been for 3+ years now. So I feel I'm in compliance because of the yard debris and the fence panel that I went and immediately took care of based on your letter. I don't have any idea how I can get a green pool non-green when I don't have access to the property. I do believe that since the fence is up and it's secured, fully secured, that I should be in compliance because I don't think that somebody should be having a violation for having a green pool.
Our code is very specific about pools and unsanitary conditions. Pool water has to be clear, and the pool equipment has to be operational so as to provide a clear turnover of water every 12 hours. Now, your option would have been to shock the pool and put a cover on it, which was included in the notices. We have not had any contact from you. Our phone number is clearly stated in all the letters that went out. You should have contacted us, and we possibly could have worked with you through this. But since this is the first time that you're communicating with us, you know, the pool is not covered. The pool water is still green, and unless we get a call to go out and inspect the property for compliance, the fines are going to continue to run.
Continue? I didn't realize I was being fined.
Fines are running as
I
of the
thought-
date, your compliance date was supposed to be August 28th, so they've been running since August 28th at the cost of $100 per day.
I thought today was the hearing, the final hearing.
And it's for the affidavit of not to accept the affidavit of noncompliance.
Okay, at this moment, I'm going to close the public portion of the testimony. And
I'm going to direct you back to the action. The question is only, is he in compliance or not in compliance? So you either have to accept the affidavit of noncompliance, or you need a motion to find him in compliance. Those are the only two things that you should be doing right now.
do we go straight to motion?
Yeah, I would suggest that.
Any motion from the board, please?
I'll move to accept the affidavit of non-compliance on case number 14-8000270.
Second.
Okay. Any discussion?
I have a question for Ms. Sainer, if I might.
Yes, please.
Okay, in regards to the fact that this company Safeguard is now basically in charge of this property,
Right.
has any effort been made to contact them, particularly in view of Mr. Kaczynski's testimony that he has no access? What's done is done. Now we want to resolve this problem.
Safeguard is trying to resolve it. They did go out to bid to get the pool covered. Because since there's no electricity to the site, the only option for Safeguard is to put a cover over the pool.
Have they done that?
Not yet.
Okay, but is that something that you anticipate that they will be doing?
Yes,
You've worked with them before? and-
yes, many times.
And that would resolve the problem?
Yes.
Any other questions for the city or Mr. Kaczynski?
You have a motion on the floor.
May I have a roll call, please?
Ms. Dabbs? No. Mr. DeMossis?
No.
This is not, let me just make this clear. This is, the question is whether or not the affidavit of non-compliance should be accepted. The motion is to accept the affidavit of non-compliance, just for clarity's sake. So,
Ms. Dabbs, is it? No? I'm sorry, I can't hear you.
Ms. Dabbs, could you speak into the microphone, ma'am?
Oh, I'm just saying, did he say to accept?
the motion is to accept the affidavit of non-compliance. That's the motion on the floor. I just want to make sure that it was clear because there were some questions made after the fact. So,
Well, before she answers that, can I ask you a question, Mr. Trask, just to
Okay.
make it clear to me?
okay.
Okay. By voting for this, if we have a positive vote, that is basically saying that we agree with the city that Mr. Kaczynski is in violation of all of these items, and by voting no, we're indicating that he's not?
No. The question is he in compliance or not in compliance? It's not, you don't have an opportunity to determine whether he's in, well, actually you do, but the question, the motion is made is do you accept the affidavit of compliance as it is? Is everything in compliance or not? That's what you're considering right now. If you want to vote no as a result of, well, he was actually in compliance of A or B and not C, if that's what you want to do, you can do that too by voting it down. But the motion right now on the floor is affidavit, accept the city's affidavit of non-compliance. I hope that answers your question.
I know what you're thinking.
Let's go ahead and continue with the roll call, please.
Okay.
Ms. Dabbs is okay with no, correct?
Yes.
All right, Mr. DeMossis is
No.
Ms. Archer?
Yes.
Mr. Kramer?
Yes.
Ms. Vicasey?
Yes.
Mr. Vesey?
Yes.
Okay, passes 4-2.
Mr. Kaczynski,
Carries 4 to.
thank you. There are procedures put in place so that when it does come into compliance, that you will be able to address and/or appeal, as I read at the beginning of the hearing, the situation and request for appeal or a reduction of the fines that have been accumulated. So you have opportunities and alternatives in front of you. This is not the end of the road in regards to this. Does that make sense? Just trying to share that.
When you get your affidavit of compliance, it'll tell you how to appeal the fine.
And Ms. Sanner would be an excellent source of information for you if you stay in contact with her.
Yeah, I believe she said that all I have to do is shock it and put a cover on it. I can go shock it and put a cover on it today, and
But you
what would I
can't get
call
in,
you?
right?
Yes.
Can't get in.
You
No,
call her.
I'll jump the fence. I mean, hello, let's figure something out. I just don't understand, like, somebody else is supposed to be taking care of this, and they're not, but yet I'm. and
Why
I-
don't you give me a call tomorrow morning at the office, and I'll give you contact information at Safeguard, and maybe you can light a fire under them. Okay?
Okay, I'll give you a call.
All right. Thank you, sir.
Thank you for coming.
Okay, you're back to your case number 5.
Okay. Agenda item number 5.
It is.
Bank owns it, but he's still responsible.
Well, but he can't get into it because of the bank. What, tear down the fence?
Okay.
It's nice to see all those faces out there today. I wish we had this much attention at every meeting. Ms. Shannon, are you ready for agenda item number 5?
Yes.
Before she does that, is there anyone here on behalf of the respondent, which is Tarpon Highlands at Lake Tarpon Sail and Tennis Club 2 Condo Association, Inc.? Anyone here? No?
No,
No.
you're not.
I want to know, is anyone here to represent Tarpon Highlands at Lake Tarpon Sail and Tennis Club 2 Condo Association? The president, the vice president, an officer of the corporation, anyone like that? Okay.
Gary, do you need to be sworn in? Bobby, can you swear Gary in, please?
Oh. Yes. Raise your right hand. Do you swear testimony you're about to give is the whole truth, and nothing but the truth? I do. Thank you.
This is case 14-800000467. The property address is 94 South Highland Avenue, and the property owner of record is Tarpon Highlands at Lake Tarpon Sail and Tennis Club 2 Condo Association Incorporated. On July 1st, we received a complaint that the grass was dead in the common area, causing severe erosion with sand going onto the street and into the storm drains. I conducted a site visit on that same day and confirmed the complaint. The property was in violation of codes 8-40, duty of maintenance of private property, 8-52, nuisance prohibitions, IPMC 9-1, International Property Maintenance Code adopted, and IPMC 302.2, grading and drainage. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was issued a notice of violation on July 2nd and a notice of hearing sent first-class mail and certified return receipt on August 4th. A site inspection was conducted prior to each notification being issued. The notices were sent to the condo association, the registered agent, and the officers. The property was posted on August 28th. I've been in regular communication with Ralph Carigliano from Rent Solutions, the company now handling the homeowners association. On September 4th, I received a voice message from him stating that someone from the city told them to stop the work. Right now, I'm going to let Gary Sherman tell you what occurred at that time.
Okay, before we do that, anybody have any questions of Ms. Sanner? Okay.
I'll be back.
Oh, okay. I thought you were done saying.
Oh, no.
Okay, sorry.
I'm Gary Sherman, the engineering project supervisor for the city. On the date that was referred to, Anthony Mastraccio, our now Director of Building and Development Services, and I attended the site and witnessed pretty much what was described earlier.
Could you just turn the microphone up a little bit?
I'm sorry.
Can't hear you.
Is that better?
Yeah.
Want me to start over? or-
Yeah, actually, yes, please.
Okay. I'm Gary Sherman, engineering project supervisor for the city. On the date that was referenced, Anthony Mastraccio, the director of developments, building and development for the city, and I attended the site and witnessed what Ms. Sanner previously described. I believe at this point in time, what we have asked for, the city has asked for, is a signed, sealed set of drawings from an engineering firm that will address the entire drainage issue for the site. At this point in time, we have not received the drawings.
So that somebody did tell him to stop work.
Yes, they were told to stop work. Order was given by Anthony Mastraccio.
Okay.
That's based on that there wasn't a plan submitted to the city?
Correct. There was work being done out there, but no plans had been submitted, no permit had been secured to perform the work.
To the best of your knowledge, would you say that they would have been aware that they were supposed to submit drawings, plans?
That's where I need to take over now.
Okay.
I actually have one question for Mr. Sherman before he leaves. So I guess that assumes that this soil erosion and sod, as described here, is severe enough to require a permit and thus engineered drawings for repair. That's what's being
Correct.
suggested?
The work that was being done included the installation of some timbers and retaining walls, so yes.
Okay, so they were attempting to remedy the situation, but didn't realize that they needed to have applied for a permit for that work?
Yes, and there were no engineered drawings to support what they were doing.
Okay, thank you.
When I issued the notice of violation, I'll read to you exactly what I put in the letter. The following violations were observed on July 1st. The grass on the common area has died, causing severe erosion issues. Sand is ending up on the streets and in the storm drain. And to come into compliance, I stated, take necessary measures to stop the erosion, either by replacing and maintaining new sod, terracing the common area, or by other means recommended by an engineer. Please contact code enforcement to let us know the course of action you plan to pursue. At this point in time, the building department was unaware of the complaint that we received, and they were unaware that a notice of violation had been issued. So there was no demand by code enforcement that engineered drawings be submitted to the city. This was, I believe, someone called the city when the work was being done, and the gentleman went out, Gary and Anthony went out and stopped the work. The HOA, Ralph Carigliano, and the other gentlemen are fully aware that engineered drawings are being required, and per a discussion that I had with Anthony Mastraccio the other day, we feel that a 30-day compliance date would be enough time for the engineered drawings to be submitted and for the work to be complete. A substantial amount of work has been done. Some terracing has been done with landscape timbers. Some of the sod has been replaced. There's still some large areas that need additional sod. It's my understanding that once the sod is installed, that will take care of a good portion of the erosion issues, as long as it's maintained. And I did conduct the reinspection yesterday, and those photos were taken yesterday. My recommendation is to find the property in violation of codes 8-40, 8-52, IPMC 9-1, and IPMC 302.2, with a recommended compliance date of October 15th of 2014, or a daily fine amount thereafter of $50 per day.
Does anyone have any questions of Ms. Sanner?
Yes. October 15th, enough time to get engineered drawings and the work done?
I believe they were notified last week that they needed the drawings. They were notified by Anthony. Anthony feels that it is, if you want to extend it out to give them ample time. I will tell you that the new HOA people are very determined to get everything taken care of. They walked into a hornet's nest. There was no money in the HOA fund. Most of the units, the townhomes, went into foreclosure. So they're doing the best they can, as fast as they can, to get this rectified so that all parties are satisfied.
It would take me till October 15th just to do the drawings. That's why
Okay.
I asked the question. So.
If you'd like to extend it to, October 30th, if you feel more comfortable with that, I would feel more comfortable with that as well. But it's a work in progress. They're showing good faith by starting the work.
I have a question, if I may, Ms. Sainer. Is this a property that we've seen previous violations with?
Yes. But it was a different HOA group, so it's changed
I thought, though, in that case, we found that one, if it's the one I'm thinking of, we didn't find them in violation back then.
I can't, what did you say? I'm sorry.
That case, the last case that I recall, I was off a year, but the last case I recall at the Sail Club, we did not find a violation in that one.
I don't recall. I think at that point, they had planted trees and they did sod, but the problem, so they were probably in compliance, but they let the grass die. But that was when the old HOA was in force and effect.
Would it be reasonable to say then that the current HOA is making every effort to
Most
respond
definitely, and
make it work?
they're keeping in touch with me. I've received 4 or 5 calls from
Okay.
Mr. Corigliano. He keeps me informed as to what's going on. I have regular communication with him.
Because they'll never get it done.
Would someone like to make a motion?
Sure.
Yep.
Please.
I move
Excuse me. Do we have witnesses of some of these people?
They are not going to
No,
testify.
they're not going to
Okay.
testify, and I'm not going to call them as
That's why that
witnesses.
statement I made at the very beginning
She
of the
didn't
meeting.
call a witness.
This is a public
We don't need
hearing
one.
for the purposes of a quasi-judicial proceeding. They have the right to be here and listen to what's going on.
fine.
Yeah, but they do not have the right to testify.
Okay, there were at least 2 people, though, that came in after you gave that statement. That's the only
Okay.
reason I pointed it out. There's a lady in the back that wasn't
point.
here to hear it. There was another gentleman also, so I didn't
Good point.
want to go to a vote and then find out that we did have witnesses for whatever reason.
Is there anyone here to speak for the Sail Club HOA, any officers present?
Yes.
Tarpon 2.
2. 2. Okay,
Thank you, Mr. DeMoss.
that's a
Okay.
good point.
So-
That's a good point.
So I would like to entertain a motion, please.
Okay. I move based on the testimony, evidence, facts presented in law that at the time of the alleged violations, 8-40, 8-52, IPMC 9-1, and IPMC Section 302.2 of the Code of Ordinances of the City of Tarpon Springs were in force. The respondent has until the November 15th of 2014 to come into compliance with the code sections, or a fine of $50 per day shall be imposed for each day thereafter the respondent remains in violation of said code sections.
Second.
Any discussion? May I have a roll call, please?
Ms. Dabbs?
Yes.
You take control.
Mr. DeMosses?
Please.
I don't give a shit.
Yes.
Mrs. Archer?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
Yes.
Mr. Bessie?
Yes.
Your motion carries.
Thank you. All of our affidavits have been addressed?
Yep, you've got them
Okay.
all.
Any old business? No old business? No minutes to approve? Public comment? No?
Yeah, you can open it up, but we just need to, they're not going to address that case. You know, they can't address that case while it's on.
Do I dare open it up?
Yeah,
At this time, we'd be willing to accept some public comment.
but not on any case that's been heard today.
Justin?
Yes, Ms.
Can I
Santa?
just make a statement?
Yes, ma'am.
The intent of code enforcement is to bring properties into compliance, not to fine them. And if a property owner is cooperating with code enforcement, we will work with them, and we will do our best, and I'm sure, and insist that they do their best in bringing the property to compliance. It's not about fines.
Yes, Ms. Santa, thank you very much for reminding us of that. We're often very reluctant to do that portion of our job. Okay, then, so
Wait a second, we got board and staff comments?
any board comments?
I have just one thing I want to go over with the board.
it's kind of an odd situation. You hear it every once in a while. I just want you to know what the law is. When you hear a property come up here and say, I abandoned the house, I've been gone for a year, 2 years, 3 years, the bank now owns it, or it's in foreclosure. Not true. If the property owner still owns it, and the way you know the property still owns it is because that's why they're here. That's one of the things that Ms. Sander does, is make sure who the property owner is, because the city does not cite the bank, because they're not the owner. So when you hear somebody sitting over there saying, I have no control over it because the bank now owns it, that's absolutely not true. And if you hear somebody sitting over there saying to you, well, I'm locked out, well, it's your house. You break a window, you break a door, you break down your fence, you do whatever you need to do. It's your house. You can do whatever is necessary to bring the property into compliance, just so that all of you know that. So these excuses that you hear about, I don't have any control, they absolutely have control. They just don't want to take control. So the only exception to that would be if a court-appointed receiver has been put in place. And I will tell you, if a court-appointed receiver has been put in place, that person would be here at the hearing, and they would be talking to you, and it wouldn't necessarily be the property owner. Receivers are paid to make sure that these types of things are done. So it's very, very unusual, first of all, to have a receiver appointed. So when you hear things like you heard today, that I have no control over what's going on out there, that is absolutely not true. So the law allows you to take care of whatever you want at your own house. You own it. You can do what you want. Whether or not that the bank has legally or illegally come in and changed the locks and put locks on gates and those types of things. So
That's the thing, you know, if I saw somebody put a lock on the place, I'd be afraid to break a window.
why? You own it.
He knew he owned it.
Yeah.
Thank you very much,
I-
Mr. Trask.
I guess.
I will share with you something that I heard from, that one of the property preservation companies told us at conference, was that typically when they're notified by the bank that foreclosure is in process, they will change the locks typically on the front door, but a side door remains under the original owner's key, so that the original owner can still get into the property and take care of whatever needs to be done. And as far as, usually once a property preservation company takes over, they put a sticker in the front door or front window with contact information. And on this property, on this property in question, there is a sticker mentioning Safeguard Properties. So, and once we find those, we do contact them to let them know there's code violations, and we do that either by phone call or email.
Well, I understand wanting it locked because people go in and clear everything out of there, including the coppers, so it's like,
And they have the legal right to do that, by the way.
what, go get the copper?
They can take their appliances out of the house. It's their house. They can do whatever they
Yeah.
want to their house. They may be responsible to the bank ultimately to have to pay to have it repaired. And I don't really mean that in the form of they're going to get a bill, but it would be a deficiency judgment that the bank would get against them because the value of the property has been reduced so low, it doesn't even meet fair market value because they destroyed it, they damaged it, that type of thing. But the property owner, it's your property, you do what you want with it.
Okay,
So,
good to know.
okay.
So if I go in the foreclosure.
I'd like to make a comment regarding my vote, if I could. All right? And I was not aware of the technical information that you brought forth, Mr. Trask. I'm not an expert. I'm a retired railroader. However, I felt that he had complied with at least 2 or 3 of what he was charged with, and I just felt that since Safeguard had been contacted and there could be an effort made, that I just did not want that fine to continue to run, and that's why I made my vote. And even in light of what you've indicated, I would continue to vote the same way. Of course, being a Greek, I don't ever think I'd probably change my mind anyway, and that's the end of my comments.
Well, and one other thing, just so that you know, you could have made a motion to find him in compliance with code section such and such and such and such, but the other one was not in compliance, and so overall, the board order was not complied with. So you could have made, and that's where I thought you were
In
going.
retrospect, it probably would have been a better idea to do it that way, but
Yeah, but
nonetheless,
then
Understood, that's why I thought you were
hopefully
going.
it's going to be taken care of, and that's our purpose here, is not to necessarily fine people, but to get things straightened out for the safety of Tarpon Springs and the benefit of the neighbors, so.
Absolutely.
Ms. Stubbs has something to say.
I just want to say quickly that my vote, and I voted based on the fact that he said he was locked down, he did not have access, and I wasn't aware that he could break in legally into his own house, you know, so.
Well, we got educated today, both
Well,
you and
yeah.
I.
Well, they locked it because he left it open. He'd abandoned the house and someone had to secure it because he hadn't, someone hadn't done their part. And he was using that as a reason not to take responsibility. That being said, at 3:15 on the 10th day?
11th.
The 11th day of September 14th, I'll call this code enforcement meeting to a close.